Okay, I'll speak in Hebrew. I have graduated, or I've finished on the 30th of April. I retired from the army. It was on the 1st of May. I became a civilian after 20 years of military service. I was throughout that time in the International Law Department. Daniel preceded me, and Gil perhaps will follow me in the future. At the moment, he's the head of that another department, and I started teaching at the university, and today was the last lesson, the concluding lesson of the second semester. I only taught at the second semester, and I told my students today in the final class that this experience, studying at the university, actually forced me, teaching at the university forced me to learn as well. I did study those issues in my service in the army, but here I had to study and find every detail that pertained to the subject. I had to read a lot. I had to read the basic literature, and this combination that course allowed me to make only sharpened the insight that international law is connected, deeply connected to the practice, that it is such a field that is evolving, that is dynamic, that is flexible, that is adjustable to the various changes which emerge. And I think that it's extremely important to truly maintain that connection in the academic world as well, without underestimating the importance of the analysis of theories and also the academic theoretical discourse. This combination to practice in general terms is conducive, but mainly here it has a very significant contribution to identify various topics and develop this field. So indeed, I think that I had a rare, interesting opportunity in that respect. But no, I did not encounter any problems in the Tel Aviv University, except for one professor or another that definitely would not characterize the collective. I was welcomed there very warmly. And now for the topic at hand. We are forced to contend with a situation in which we have an enemy, the Hamas mainly. We also have the Hezbollah, but it's not defined as a state. It's a non-state entity. And second, it doesn't operate in the conventional means of war. It uses various non-conventional means, subversives, insurgent means, hiding within their population, working against the home front, and it doesn't respect the laws of war or undermines quite deliberately the safety of citizens. It imposes and impersonates as civilian, and it's done in very condensed, crowded, civilian-populated areas. Now, what does that mean about the laws of war? 10 years ago, about 10 years ago, when discussions were held and Daniel and myself were engaged with them concerning what would be the rules that apply here, the debate was whether the rules that apply in this situation of fighting against the terror organizations are those of law enforcement. Are we talking about criminals that we have to use law enforcement instruments against? Or we can relate to the situation as an armed conflict situation and revert to the relevance of the anti-war rules. Can we exert force in order to harm, like we do in a war, against those who are defined as enemies? Or do you exert force in order to arrest or to impose order, which is the law enforcement case? About 10 years passed, and in the middle, there was 9/11, of course, and that major terror attack. And the debate today, the controversy has changed altogether. Today, there's hardly any controversy or any disagreement about the fact that in certain circumstances, organizations We're not just bound by the law enforcement rules, but there can be an armed conflict against a terror organization, and then definitely the laws of war apply. Still, there are questions how we integrate both law enforcement and war laws, but as a basis, we did make great progress, and this progress was made in a time that is relatively short, less than a decade. The debate nowadays that is going on is, okay, even if we are in a situation of war and the laws of war apply, there has to emerge a question whether these laws apply to this type of war, or perhaps we need to come up with new rules, perhaps the old ones don't apply anymore. Now, there's an argument here that is heard very often. By the way, it is heard more from people who do not come from the content world of the international law, that say that the existing rules are inapplicable, they're not suitable. They did, having in view the wars of the past, they're not compatible with fighting against a non-state entity, and we need new rules to be formulated. Now, the basis for this claim, or the arguments that back it, say that, first of all, the tools that, or the laws of armed conflict were based on the vision of armies and countries fighting against one another, a conventional war, but they're no longer suitable, therefore cannot apply. And they say the laws were written down in a situation in which reciprocity was possible or feasible, where both sides adhered to the laws of war, to gentleman principles and knight principles, and when one side applies these and the other doesn't, then these are rendered unsuitable anymore. So in the short time that I have, I would like to argue that I do not accept this argument. I do not think that it's the right one, and nobody should even claim otherwise. I believe that the rules and the laws of war are all in all good laws, that they are relevant even for counter-terror war, and that we can get along with the existing laws with making certain amendments and adjustments, and I'll relate to these adjustments. And these statements, not only are they not necessary or feasible, but they're also harmful. So first of all, I won't go into the historic questions where the laws were written having these conflicts in view. But I do think that if we do examine this, we'll see that over history there were conflicts that weren't conventionals, that weren't between the states, and the laws of war did apply to them. So it's not exactly precise from the beginning. But as for reciprocity or mutuality, the laws of war, perhaps originally in the very basic perception, come from knighthood principles. But a long time has passed since then, a lot of water under the bridge, and conceptions have changed since then. And the basic principle that underlies laws of war is not the respect of the honor of the other side, and whether that is infringed or not, but rather the idea that we have to defend as much as possible those who are not a part of that war, those who are outside of the war, civilians, protected targets, and that the damage that they incur as a result of the fighting would be minimal. This is the main rationale, and this is why there's no reciprocity involved in there. That's in most cases. There are cases where the reciprocity principle appears, but it's not the main thing, and it's not any of the main pillars. As far as I'm concerned, this statement is inaccurate, and it's also misleading because it ignores the way international law has developed. International law does not develop by way of writing new covenants, new charters. Now that we have a covenant, we have very clear, strict rules that we have to adhere to, and now some time has passed and these are no longer applicable, and we have to sit down and write a new covenant. It doesn't work that way. The way international law developed, and the laws of war are an excellent example for that, is that of practice. And that means that the deeds and the acts of countries and the way they operate, including the way they explain their conduct, is what generates the law. And the meaning of that is that the minute countries encounter different types of threats and development of new situations, such as the terror organizations in belligerent situations, and they act and implement principles and rules with adjustments that are required by the new situation, and these adjustments that they carry out are actually creating that new law. And this is how the laws of war have evolved over the years, and I believe that that is the way they should continue to evolve. First of all, there's no real tangible alternative to that. If you think that you can sit and convene the entire world and reach a covenant that would set better rules than the ones we have, it's not really connected to the way things work in international law. That's what we have. That's one thing. And the other alternative of saying there are no rules or laws is one which, practically speaking, is something that cannot be applicable. I say this from the practical side. You cannot say there are no laws. You have to give directives. You have to be working with some laws, and these derive from what you have. You derive them from the principles, from the existing laws, and you make the adjustments whenever necessary. This does not mean that we're pulling tricks or any things like that. That's the way we activate the international law. When the Americans tried to argue concerning the Guantanamo prisoners, because that is something new and that is a new conflict of a different type, and it's not regulated anywhere, and they don't have any rights, and you can do anything you want to them, they definitely were attacked, and criticism was leveled by every part of the world, including their own conservative court that usually does not intervene in security matters. They too began to intervene, and if the U.S. cannot do it, let alone us, and I don't think that that is necessary. I believe the Americans could spare themselves of all that and do various things, and by analogy implement various laws of detention, and they would find themselves in a much better off situation with a lot less tensions around the Guantanamo case. So when I think about the practical aspect, what are the relevant principles and how do we apply them? The main one, or the two major principles that are relevant for this issue, is first of all the distinction principle. The issue of the principle of distinction is by definition something that has flexibility in it. It says you distinguish between a military target that is legitimate for your attack and a civilian target that you should not direct your attack toward. Now, what is a military attack? To begin with, this is very flexible. A military target that is being used because of its location, because of the use, because of the potential of its use, has a military advantage, already turns into one that one is allowed to attack. So there's flexibility that is embedded in the rule. The same goes for people. The dichotomy between fighters and civilians. If in the past we started with the targeted killing in 2001, and we didn't know what to do and how we related to those terrorists who are dressed like civilians, and there was some innovation by saying that these people too are legitimate targets for attack, even though back then we had this nucleus of civilians that lose their immunity. I'm sorry that I missed the first part of this conference, but I understood that a lot was said about the Red Cross work and the direct participation of civilians in hostilities, and he's a bit critical about the product of their work. But if we let this aside, then the concept shows a great progress made since what there was at the beginning, where everyone was civilian back then and they had to be stopped, in comparison with the understanding that there can be a conflict against a non-state entity, that those active in the military aspect of the organization lose their immunity as civilians, or are not even considered civilians. They actually are removed from the circle of civilians. And this is what appears in the guidelines of the Red Cross, and that shows development, and it simply shows how international law develops through practice. And this development is because of the practice generated by the US and Israel, and the insights it generated in other countries as well in similar such conflicts. So that's as far as the principle of the distinction is concerned. The second leading one is that of proportionality. The principle of proportionality is also one which sometimes has a lot of misunderstanding around. What does it mean, this principle? It says that an attack is legal as long as the collateral damage incurred to citizens or protected targets is not exaggerated with respect to the military advantage that emerges from the attack. Immediately in this formula, one can see that there is an advantage, a certain priority or preference is given to the military advantage, and only if the damage is exaggerated in comparison with the first, would that be considered unproportional. When you have an area that is saturated with population and a great fear that many civilians would be harmed and their possessions as well, does it mean that you cannot operate there? No. This principle is flexible. It says, no, way the military advantage, compare it with the expected damage, and now strike the balance. This gives the commander that needs to make the decision a framework of considerations he has to weigh. What would be the advantage? What would be the risk involved? And now he has to strike the balance. What would be the right answer? If he took all those considerations, then legally, and he makes a proper balance, a reasonable balance, then definitely he passed the test. And here moral and ethics come along, and they don't extricate one another. They do not rule out one another. They don't come one in the place of another. It's not all moral or all law. We have the law that gives us a set of rules, the order, the things that need to be considered, and it turns those weighing them into more professional soldiers or commanders. And then there's the decision itself where ethics come into the picture. And that's a bit of a charged concept. It can also be subjective. So I met with an expert for ethics. She said we shouldn't be speaking about moral, but rather about values, because the army cannot operate according to the subjective moral of a particular soldier or commander, what they heard from a certain mentor or rabbi or any influential factor. Values are something that is more definable, and the army defines with the ethical code the values that he expects that decisions would be made according to. Usually, moral and law lead to the very same target, and usually they lead to the same destination, but moral has the upper hand. But I believe that that is the way they operate together. So the entire discussion that was held concerning the risking of the lives of soldiers, does it have ultimate preference or not? I'm not that an expert in ethics, and I have my own opinion, but legally speaking, definitely one can weigh the consideration of risking the lives of soldiers. That definitely has the significant advantage of the military aspect. Should I disregard the safety of civil population? Of course not. I do not implement these rules properly if I only consider the safety of soldiers and not that of civilians. But I do have to expect what it means when we compare the two and then see the balance. If I made my considerations, then the balance is bound to be okay. And two commanders might make totally contradictory decisions to one another. And the jurist doesn't go there to replace the commander. The jurist is not even present in the battleground, but even if he is there, he is not supposed to replace the discretion of the commander. The discretion as well as the decision is that of the commander ultimately.
So, when we talk and when certain statements say there are no rules, the rules are not applicable, they cannot be applied, well, first of all, there are principles, there are regulations, and we have operated and are operating based on these laws together with the chief military prosecutor and other senior legal officials. The legal consultancy in CAST led. This is not something I made up. We applied the existing rules and laws. People say that the rules are not suitable and we cannot operate based on these laws, and Israel cannot operate with these laws. All this creates tremendous damage because, first of all, it is incorrect, and I think people don't understand it correctly, because then what happens is we both abide the rules and then we don't care about the rules. So this creates diplomatic damage which undermines the legitimacy of the operation. It is simply unnecessary, incorrect. As for the future, just 4 more points and then I'll finish. First of all, or maybe 5 points, First of all, we must stop saying that the rules and laws are unsuitable and you can't work based on these laws, and if you do, you lose. I don't think it contributes to us because we do abide by the rules. It doesn't help to our legitimacy. It only undermines it. It's not that there's an alternative set of rules that's just waiting for someone to develop it and apply it. What we need to do is to continue and operate and apply the laws and rules, but to adapt it to the situation, to do it after analysis in an educated, informed way, and to use it in places. It's constantly surprising. For 20 years, Daniel can say the same thing about his period. Every day I would encounter a new question which was not asked yesterday and which I cannot find an answer to in the books. It's amazing how many new and challenging situations come up, and the way to do it is to take the laws and to extract the rule out of it. So the principles, and extract the rules. So we need to abide the rules and adapt them to reality. Another thing we need to do is to have some kind of discourse or dialogue with professional factors to present our dilemmas, professional entities such as the International Red Cross, and we have an ongoing dialogue with them as well as other entities. You give them your perspective in this discourse, you hear their perspective, things can be developed. We mustn't give up on the attempt to influence these entities. Just recently, I met with two scholars from a distinguished academic institution abroad, and inter alia, their task to train UN and NGO workers who go to war zones. And they said that it's very important for them to hear me, to hear the perspective and dilemmas of people from the military in order to explain. In these sessions, they instruct that you can't look at everything only from the angle of the victim. You need to understand the needs of the other side, or otherwise you won't be able to promote anything. So such meetings, such statements are important. We mustn't give up on that and despair and think that we cannot make an influence. We can make a slight influence here and there. It's definitely possible on the professional levels, and it's important to publish, because I said that what's important is practice. And our practice here in Israel changes international law, but for it to change international law, we need to say and explain, to explain why we did something in a certain way, and for that we need to research more, to publish more, and in this way to have a more significant impact on the development of international law. I think that we mustn't despair. We mustn't think that sometimes there's this approach in Israel. People think that everybody's against us, and whatever we do, people are against us. I don't think that in the professional field this is a situation. Things have changed, and one of the reasons for the change are the things that we've done, and they're going to change in the future. We have many shared interests with legal advisors of other countries, which often encounter dilemmas not so different from ours. Thank you.